Law school is the reason that lawyers always look miserable. Hello! If you're joining me because you're halfway through LSAT prep and you're wondering if it's really worth it, or if you're just interested in law school, I want to break down some of the things about it that you'll run into in your 1L year and some of the other tips and tricks you can learn. One of the first and very foremost, many people say that law school is just the Socratic method. Well, Socratic, meaning you're talking back and forth and your professors are asking you questions to get your proper responses, it's a little bit different than what many people may just say that it is. Sure, it's difficult to adjust to. Of course, if you didn't learn like that previously, but what really usually happens is you are asked a question, and then your professor talks quite a bit in lectures, and then you're asked another question, and you will usually be what is called cold called, meaning there is no prompting, it's just you, Mason, please answer this question. And then you, some random person across the room, maybe it's alphabetical order, maybe it's based off of where you sit in the room, or maybe it's based off of volunteers. People think that law school is just, I'm going to call on some random person and cold call you and make you super scared. This doesn't always happen, but it sometimes does. Certain professors have different methods that do it, and I'll be honest, you can kind of game the system occasionally. And if any of my professors ever see this, I've never done this in one of your classes, I promise. Basically, if you volunteer to ask a question or volunteer to answer a question, you're allowed to ask questions in law school. It's not just your classmates trying to get the proper answer. You're allowed to ask your professor. That's what the professor's there for. So if you volunteer to ask or to answer, there's at least a chance, a better chance, that you may not get cold called sometime in the future. However, that is not a foolproof plan. So yes, it is possible to get cold called, but some professors do it in a different way. Now, what about the teaching styles? Is it always Socratic, or is there like lecture, like college or high school still in it? The answer is, well, it depends. And frankly, you're going to learn that law school, the answer to almost everything is it depends. Frankly, that is the answer for just about everything. But some professors absolutely love the Socratic method. They are going to absolutely drill you until you're dust, basically, for asking you questions and trying to get to the heart of the matter. Some people do that just because you showed up late to their class and they wanted to make you look foolish. Other ones genuinely do it to try to get to the heart of things. Other professors lecture. They ask for your input, but it is usually not a please answer this question. It's a what do you think of it? And that brings us to one of the big differences when it comes to law school. Most of the time, if you have ever looked at law or politics, you will have talked about policy and not law. Of course, there are some places where you may have talked about law and the legal process of how you get there, but policy is why the public thinks it should happen, or why the legislators think it should happen. Usually, the legislators are supposed to do what the public thinks, but not always. Not always. And we see that pretty blatantly. But the law is different. Many people think, oh, lawyers, they just care about the laws. Well, let me tell you, all of these books back here, very few of it is actually just the law. The stated regulation passed by the Congress or the state legislature, or if it is a regulation from an agency. Very rarely do you get to talk about a case in law school where it is just, this is what the law is. There's questions about what the law means, what the context of it is. How did we get to this point? Is there any legislative intent? And we've talked about some of these other things on this channel before, and I'll link the video up in the little corner up here. But other than that, what do you mean by the law? And it's different, and it's not just what's wrote down in the statutes. Well, there's things called case law. And if you've looked into law school, you definitely know what I'm talking about. But case law is what takes up most of what you're going to learn. You learn different cases. For example, and I'm only using abortion because this is a more well-known one. Roe versus Wade was a precedential case for a few years. And then there was a new case. You had, of course, Casey versus Planned Parenthood, and then that was a precedential case for a while, and then you had Dobbs v. Jackson Women's Health, which is now precedent. And precedent means kind of the prevailing case and what we look at when we're looking at that legal issue. However, just because there is a case that is precedental, that does not mean that we completely disregard everything that's happened in the past. There are some really important, say, arguments that may come from older cases that may be brought up in certain places on, say, an exam. You need to at least somewhat know what those other cases are that aren't precedental, because sometimes even dissenting opinions can become majority opinions later on in different cases. And to kind of show that, let's look at, I'm worried that's all going to fall. Let's look at my evidence book. How much do you think this is actually evidence rules? Well, actually, none of it. Almost all of this is case law. And you can go through here and see every single one of my briefs, and we'll get into briefs a little bit later, but it's very important to note most of the things that you will learn are not going to be just the laws. And next, what to expect when you go to law school. If you're going in thinking that you are going to be learning the law from your state, you're mistaken for the most part. Sure, there are some electives that you might be able to take, or there might be some brought up law from your state, but that doesn't mean that is all you're going to be learning. For the most part, you will learn precedent. You will learn different types of law. For example, if you're learning property law, you may be learning about a property law from your state, which is cool if that's what you wanted to do. But usually you're going to be learning property law from everywhere across the country. And if it's the common law, if there is a uniform code for it, so for example, the UCC from contracts, or for example, you're just going to go straight federal, which it would be like evidence, like I just showed. Now that, of course, is up to your professor because it, depends. I'm trying to really get that into your brain because it depends is truly the correct answer for almost everything. Next, your briefs. What is a case brief and why is it important? Well, for homework, and you are expected to do this before the next class, you are usually assigned quite a few cases to read. And there are many different types of cases because you have many different classes going on, but you usually want to write a case brief with some very basic information that can help you get through the class if you are cold called. You would want the facts, the holding, the reasoning, and a few other things like that. Usually, most professors tend to not care where the case is or what the case citation is. However, sometimes it is important and that will come up depending on what type of class you're in. So when you're talking about the facts, you don't want to hit every single fact because you're going to take up your entire notebook, your entire Google Doc of space, and you're not going to be able to skim it to figure out what you're supposed to be talking about. You try to break down only the most important facts. For your holding, this is usually what most people think that people in law school care about. And really, it's not, but it is still very important. This is, of course, what makes the precedent, but the reasoning is what really we look at going forward. So the holding is what the court rules, who won the case, and why they won the case occasionally. But the reasoning is really the why. How did we get here, and what are we supposed to do when we're applying this? For example, substantive due process is really something that came about in reasoning. You may be able to say, oh, the Constitution has the right of abortion, or the Constitution does not have the right of abortion. And frankly, people are going to always say, well, abortion, the word, does not show up in the Constitution. And frankly, neither does privacy. So we're having things like that come up in the reasonings. We expected this because the founders said this, or we expected this because of this is what the law said and this is how it acted. For example, with Sibelius versus NFIB, they have specifically, Congress said that something is a penalty when it is in fact what the court ruled as a tax. Now, the reason that matters is because Congress can't pass penalties, but they can pass taxes. So there's a lot of things like that. It's really important that you write down how they got to that conclusion. And one of the famous things from Sibelius is if it walks like a duck, it quacks like a duck, it's probably a duck. And that's something you will most certainly hear in law school. They usually rule with what it looks and what it acts like, as opposed to what it is called. And that's a little hinty for once you get there, but that's not super important for this video. Now let's move on to what classes will you actually take as a 1L? Now, I can't say for certain for every single ABA accredited school out there, but usually in your first semester, you will take a mix of the classes of property, torts, contracts, and civil procedure. And there's usually a legal writing, and there's different, of course, titles that those classes take on, but usually there is also legal writing in there as well. And after that, the schools tend to diverge a little bit. Some places have it in your 1L year, which is your first year, you take all those core classes in the first semester, and then you take the second version of those classes in the spring semester or your second semester. So, for example, I was a little bit different with my courses that I took. I had my 1L semester, my first semester of the entire time there. I had torts, property, legal writing, then contracts, and civil procedure. In my second semester, I had criminal law, torts 2, contracts 2, and civil procedure 2. So I didn't have as many classes that second semester, but then, it was still something that was kind of difficult to get through because there are so many new concepts that you just learned that first semester that you just completely jump to something jumbled and horrific after that. But never fear, of course, this is a learning curve. Law school is something that is scary, but it is something that you can certainly learn and adapt to. Now, what about in the classroom? Aside from the cold calls and other scary things, what can you expect? Well, it is usually a really big room that has a lot of people in it. Who would have guessed? But certain professors are kind of stuck in the past and they won't allow you to bring electronics. They won't let you have a laptop, they won't let you have a phone, so you need to print out everything. And that is what my professor for evidence was. This, a notebook, and my printed out briefs were all that I was allowed to bring. So, I stuck my briefs in my book. And this is United States versus Owens, if you care. But here are my briefs. I have them all printed out and I have them stuck in my book so I can easily get to them because obviously I can't have it on my computer. But other professors are very different. Some of them even allow you to record the classes. But keep in mind, it is very important. Some places don't, so do not go in there with the assumption that you are allowed to record. Now, some tips and tricks. Of course, there's a lot of different things for law school that you're going to learn yourself, and certain things work for certain people. Certain things don't work for many people, but it is something that may work for you. Something that I learned when I was doing my initial case briefs, I really focused on some of the things that didn't matter. And I had another video, and I also referenced this earlier, about how I went to school for political science, and I found that it actually harmed me more than it helped me when I was first transitioning into law school. I thought that the case citation mattered, I thought that the party names really mattered, and I thought that all of that really mattered. And frankly, it really didn't for some of them. When I was in my property class, I tried to read all of those things off of my case brief, and my professor looked at me and asked me if I even prepared for class whatsoever because I was stumbling, because I wasn't answering her questions. So, make sure that you know what your professor wants, and it may be a really crazy thing to say, but certain things can change. What is expected of you may change from your certain classes. Some people will just harp on you for no reason. I watched people cry in class. I've watched people just walk out of class and drop the class immediately afterwards. And that's something that happens. But you, I'm trusting you, are going to be resilient and make it through. Another thing, and this is not something I recommend for your first semester, but your second semester, it could certainly help. I outsource some of my brief making to AI. I have Gemini prompted up a ton to be able to get exactly what I want. Because when I originally started writing my prompts for it, I just said, make me a case brief, and then it goes off and does whatever AI does. But when I was originally handwriting them, it helped me learn the cases better. And that is really in your foundational time where you're trying to learn, okay, what facts are important? What type of legal conclusions or things like that are important for me to know? And that is something that you can use also outside resources to help you with. When you're briefing, you can sometimes look at different places like Quimby, for example. That is one that a lot of people use, and I know a lot of people like. So, like I said, please don't do this your first semester. If you're really struggling, use Quimby to help you brush up on maybe some things that you might have missed, but don't solely rely on them. I watched a person in that same property class start citing facts that weren't in our casebooks. And it's really important that you go by the casebook because most of the cases are much longer than what we are provided in our casebooks. So if you are looking at, say, Quimby and you say, hey, give me a brief for this, and it talks about facts that aren't relevant, your professors are going to know that you're not putting the work in, and they might actually go after you a little bit more and nitpick you a little bit more. And that reminds me of one thing I didn't say earlier. A lot of law schools have what are called anonymous numbers and anonymous grading. And if you didn't know, a lot of law schools give you your exams where it's a maybe 15 to 25% final and an 85 to 80%, an 85% final and a 15 to 20% midterm. I know the math doesn't math very well, but work with me, please. I'm going to school for law. I'm not going to be an engineer. So it is very weighted for a final as opposed to other things like when you were in high school or when you were in college, where you usually have more quizzes, you have participation points. And don't get me wrong, you have participation points in law school, but that usually is because if you don't show up to class enough or don't participate in class enough, some professors may actually mark you absent. And you are not allowed, per ABA rules, to sit for a final exam if you've missed a certain amount of classes. So, of course, it's a proportion of classes. It's not, all right, if you miss more than 5 contracts classes, you're done. No, there's an actual proportion for that, but it is important to, well, of course, participate, but it is also really important to pay attention to what is really important when it comes to grading. And because of those anonymous numbers, you will not have biases from your professors against you. Now, keep your anonymous numbers private so only you know it. And I'll give a quick little story. I did really well on my first contracts midterm. And I mean, life has been downhill from there, but I scored the highest in my class. I did really well. But then everybody found out because they then looked at my anonymous number. And let me tell you, law school can be cutthroat. People were targeting me, like trying to figure out, like, hey, how do you study? How did you do so well on this? Frankly, I guessed on a few of those questions, but it was an educated guess, so I just must have gotten it correct. But people will look at you differently when they think you are a top of the class, or they'll look at you differently when they think you're the bottom of the class. Frankly, it's really important to try to just kind of stay in your lane. Things are cutthroat in law school. Another really important thing is that you are asked hypos or hypotheticals almost constantly. That is what your exams are based on. That is what a lot of in class discussions are based on. And what do I mean by that? Well, usually you are going to read a case, and then right after that, your professor will ask you a question. Say Blackacre in property law is being sold for this amount, and there is a certain type of, say, tenancy in common going on there. And of course, you may learn these terms later on, but they will say something and then they'll tweak a fact. It's almost perfectly mirroring the case you just read, but they want to know if you can apply what you've learned to that hypothetical. And when I say that it can be a hypo just about anything, I'll let you know that I've had hypos on exams that were about the Munsters blowing up their, say, neighbor's porch. I've had things about Cindy Lou Who and the Grinch, and how Cindy Lou Who pointed a BB gun at the Grinch, causing IIED, or the intentional infliction of emotional distress, and whether or not the Grinch should have known that it was a BB gun and not an actual gun, and if we could charge, or I should say, sue Cindy Lou Who for doing that. I've also had absolutely soul crushing questions. I had for criminal law a 4-page long fact pattern. And I'll be honest, that's kind of par for the course for some of these classes. You will have a lot of stuff to read before you're even asked the question. It's soul crushing because the hypo was about a man and a woman in a relationship. They were both drug addicted, and the mother really cared for her newborn child. The father absolutely hated the newborn child and would abuse the child at almost every single chance that he could. Where the mother would take the kid to the hospital to get him checked out, do all of the different care for it, and eventually the father drops the kid on its head and kills the child. Now, that is soul crushing because it is a question of reality. But what's even worse is I was asked what we should charge the mother with. The correct answer was murder too. That's horrible. That is one of the absolute most soul crushing things. And it's actually something that lives on my mind after that. I can chuckle about the monsters or how the Grinch stole Christmas, but really, some of the soul crushing realities of the things that you have to come to life is also part of your hypotheticals. Now, I don't want to scare you too bad. That might just have been my professor really not having a good day. But it is important to talk about how you are not usually answering real world questions. You are answering questions that your professors came up with. Of course, when you watch different shows like say Law and Order, they'll say, "Oh, that's a bar exam question." Because it's a random horrible hypothetical that you need to answer every single thing. And to go further from that, when you're answering say your essays on exams, you are usually using something called IRAC format. It means issue, then your rule, then your analysis or your application, depending on who your professor is, and then your conclusion. And of course, there are many different variations of that. There's CRAC, which is conclusion, rule, analysis, conclusion. There's CREAC, and there's so many different other ones that I can't go into all of them in this video. But just know that there is a formula to know how to answer these questions. You need to know what your issue is. Holy crap, before you answer these questions. And then you need to talk about your rules. What have you learned in class? How can what you learned in class apply to what's going on here? And then you have your analysis or your application, where you apply the rules that you learned to the fact pattern presented to you in the hypothetical. And then finally, your conclusion. How does this come out? Certain professors want you to give a concrete answer like, person A or the plaintiff wins against defendant because of this. Some of them want you to leave it ambiguous. Of course, that's something that is kind of hard to do, but usually there are some up in the air facts. And let me tell you, if they give you facts, they're usually important. But there are up in the air facts that may make it difficult to come to a concrete conclusion. But make sure you know what your professor wants, of course. I also wanted to talk about some of the problems that people have with ambiguity. And of course, I've had this as well. Not every single thing is cut and dry. Of course, I mentioned with exam patterns and things like that, how it's kind of hard to always give a concrete answer. Well, there isn't always a concrete answer. Certain cases you are going to read will inevitably have different types of rules that make you kind of balance it. There's a balancing scale, and certain factors may weigh more than others, but there is never a definitive, well, say factor A is worth 1 point and factor B is worth 3 points. You need a threshold of 4 points, and say factor C is worth half of a point. Just because you have factor A and factor B doesn't mean it automatically passes. You really need to think about kind of the whole situation. And of course, I'm not saying you need a totality of the circumstances or something like that, but it's something to think about. The law is not black and white. You need to be able to kind of work within a spectrum and actually have it work for you. And usually you need to have an argument to back it up. If you're answering something on an exam, or say even a problem in class, because you're not just assigned cases, you're usually assigned problems as well, at least sometimes. You have it depends. It depends. We always got to come back to that. But you will have different needs to answer them. Okay, is this evidence hearsay? Is it not hearsay? Is it a hearsay exception? Now, why? What is the purpose of it? Is it to reflect upon the statement to make it true? Well, okay, well, that's out. Now, is it being used for another reason? Are we trying to get around something else, like, say, the propensity box or something like that from evidence? Well, Is it being used for a certain reason? Is it being used to show motive? Well, maybe kinda, but it's also being used to state the truth. So we really need to work out our arguments for why it is used in a certain way or why it is not being used in a certain way, because sometimes you need to argue in the alternative of yourself. And this brings me back also to exams. When you are filling them out, when you are writing down your answer, you may believe something is true, but you need to expand as much as possible. Many law school exams are not based off of did you get the correct answer, it's how did you reach your conclusion. And that usually comes down to how in depth your rule statements are and how in depth your application was. And it's really important because you want to expand as much as you are able to within your time period. Of course, pace yourself. Usually, you'll have more than one essay question, and it's sometimes hard to go as in depth as you may want, but you need to be efficient. If you're going to talk about, say, substantive due process, you really want to bring up the 14th Amendment. You may want to talk about specific things that you've talked about within, of course, SDP. You may want to talk about certain things related to the facts that you've talked about before. As I mentioned, abortion, you may want to bring up other things in your application and say that it is not like this because of this. That is a way that you can farm up extra points. And another final note on exams, some of them are open book, which is deceivingly great. You may think, oh, my professor, oh, how nice they are. They gave me a supplement, or they even let me use my notes. Yeah, that's usually because you don't have enough time to do that. It's awful, but it's also sometimes nice if you have something that's just really racking your brain and you can't remember the specific word for it, because to be fair, they will usually knock you for not using the correct words. For example, this was a while ago, but I used the over 50% instead of more likely than not, or I'm going to let you guess what the word I should have used right here in front of my face is. Comment it below, but I used the wrong word and I got points docked for it. Usually, now I didn't get points docked. I got points that I could have had on the table not used, because usually you don't lose points, you only gain them when it comes to essays. Of course, multiple choice, you need to get it right. Um, Sorry, if you didn't know that by now, I don't know how you got through elementary school. So, if you have any other suggestions for anybody that is interested in law school or even has considered being a lawyer in the future, write them below. I think it's really important that we have a list of things for people to be able to reference when they're going through one of the most difficult times of their life. Now, of course, the LSAT isn't as bad as the bar, but we'll take baby steps. You got to get through law school to take the bar, unless you're like the guy on Suits or whatever it is. I hope you enjoyed this video. I hope you come back again in the future as we have other things about AI, the law, 3D printing, and many others. Thanks again.